the file.
That's fine. I'll just deal with it. Before the system went down, I was on the Collier matter, just so that the record is clear. She waived preliminary examination. It was bound over to circuit court. So also the record's clear. She could hear me, and I double checked that she answered all the questions appropriately. And it's set for the 25th, wasn't it? March 26, 2025 at 9 a.m. 1:30 before Judge comment. That's what I meant to say. Thank you. Or it does call the case People versus Eddie Gardner. Stay on the way.
Andrew Childers appearing on behalf of people.
Oh,
Good morning, Your Honor.
oh,
You had to deal with me at some point today. You knew.
no, I really, but I will.
Great. Christina Costantino appearing on behalf of Mr. Eddie Gardner, who is approaching. Eddie, can you please state your name for the record?
Eddie Gardner.
Thank you. All right. What are we doing on this?
Judge, this is a date and time set for a PCC. At this time, we would be asking for a 3-week adjournment of the PCC to obtain all the necessary discovery.
In both cases?
Yes, Judge, that is my understanding. Is that your understanding, Mr. Childers?
Well, he's got the new case, and then
The new case is we would be adjourning for discovery. The previous case is,
An issue.
yes.
and I think we will have a resolution, well, a disposition on that case on our next date.
So you want me to put them both over to the 27th?
Yes,
I
Judge.
realize okay.
Yes.
Isn't this the one you had me move to today?
Yes, Judge. I just wanted them kept together.
Because we already had it,
Well, it would have been the
No,
20. Keep them together.
She had us move it.
Judicial efficiency.
This was not efficient.
Well, now they'll be together. You won't see us twice, back to back.
That's at least one good thing. Probable cause conference in these cases, March 27, 2025, 9 a.m. Bond will continue.
Thank you, Judge.
Court calls the case of the People versus Jerry Pickham.
Ashley Lonnie for the people.
Hi, Overdell, on behalf of Mr. Pickham. Mr. Pickham, please state your name for the court. Jerry Pickham. So, Your Honor, today's date and time set for probable cause conference. We have received video. I just haven't had time to review it yet. So we're asking for one final adjournment. This will be the last adjournment. We're asking for 2 weeks.
Probable cause conference, March 20th, 2025, 9 a.m. without objection. Bound continue.
Thank you, Your Honor.
Court calls the case of the People versus Jeffrey McCulla.
Raymond Cook for the people.
Christopher Quinn appearing on behalf of Mr. McCulla.
Oh, apologize, Mr. Quinn. Laura Yagi, Assistant Public Defender with and on behalf of Mr. McCulla. Sorry. In the case ending in
5611.
yes. Thank you, Your Honor.
5631. All right. All right, what are we doing on these cases, folks?
Well, Your Honor, I would to increase Mr. McCulla's bond. Actually, he's sitting on a personal bond. In terms of the substance of what we're doing today, I would also ask for a very brief adjournment. I spoke with the APA, and we are trying to work towards a global resolution here. Mr. McCulla is being held on another matter until he's allowed to be released to treatment, but until June is his estimated release date. So he's sitting on a personal bond in this case. So I would ask if the court would consider increasing his bond so that he could potentially earn some credit.
Quinn, what are we doing on your case?
It was my impression that Mr. McCulla was getting new counsel. Is that not the case?
Not the case currently this time.
Okay,
Was
well,
not able to do so.
I don't have a problem with the brief adjournment, Judge.
Probable cause conference will be adjourned March 20th, 2025, 9 a.m. And he's actually on, and Mr. Quinn, he's actually on personal on your case also. Are you requesting that his bond be increased also?
Yes, Judge.
All right. Bond in each of these cases will be set in the amount of $5,000. I'll give a 10% privilege on it. 5,000, 10%. All right. Thank
All
you.
set.
Thank you, Your Honor.
Court calls the case People versus D'Angelo Green.
Ashelani for the people.
Albert, on behalf of Mr. Green. Mr. Green, please introduce yourself to the court.
D'Angelo Green.
So, Your Honor, there should be a waiver, I'm sorry, an adjournment for me here. Mr. Green was given an offer. He needs a little bit of time to complete the terms of that offer. So we're asking for, I think, about 3 weeks, 3-week adjournment.
This
That's
is
why I
now like the
understand
fifth.
Your Honor.
This is the fifth adjournment on this to do this.
This should be the final adjournment.
Probable cause conference will be adjourned March 27th, 2025, 9 p.m. Bond continued.
Thank you, Judge.
I got power. Court does call the case of the People versus Sequandahala, Middleton. I had messed that up, but I did what I could.
Kyle Burdell on behalf of Ms. Sequangela Middleton. Ms. Middleton, please introduce yourself, unmute yourself and turn on your camera.
Sequangela Middleton.
Thank you. Your Honor, today's the
I
day.
have a camera.
I'm trying to fix it. I don't know. Oh, wait.
Thank you. All right.
Thank you, Judge. Today's the date and time set for probable cause conference. At this time, the people need a little more time to determine the restitution and we're working on a resolution. We're asking for a very brief adjournment. I expect we'll resolve it at that time.
March 20th, 2025, 9 a.m. Bond continued.
Thank you. I'll call you Ms. Middleton. Thank you.
Okay.
Court calls case People versus Anthony Warren.
Ashelani for the people.
And good morning, Your Honor. Sydney Rush, an opinion on behalf of Mr. Warren, who's approaching my right. Restate your name for the record.
Anthony Warren.
Thank you. Your Honor, at this time, we'd like to set this matter for a preliminary examination. The video discovery that was outstanding has been tendered, so discovery is complete.
People have their witnesses available the 18th.
Well, we will try, Your Honor. Thank you.
All right. Preliminary examination in person. March 18th, 2025, 9 a.m. before Judge Moore. Bond continued.
Thank you so much, Your Honor. Have a great day, Judge.
You do the same. Court calls case People versus Bianca Rowell.
Good morning, Your Honor. Chief Assistant Prosecutor Victoria Burton Harris appearing on behalf of the people.
Kyle Burdell on behalf of, excuse me, Ms. Bianca Rowell. Ms. Rowell, please introduce yourself to the court.
Hi, my name is Bianca Rowe.
Thank you.
Your Honor, days and times set for probable cause conference. We do need a little time to sort of gather some evidence and some documents, to talk to the people about a resolution. We're asking for a 3-week adjournment.
March 27th, 2025, 9 a.m. Bond continued.
Thank you, Judge.
Court calls case People versus Anthony Taylor.
Good morning, Andia, on behalf of the people. James Feitfeldske appearing with and on behalf of Mr. Taylor, who is approaching. State your name, please, for the judge.
Anthony Taylor, Your Honor.
Thank you. Your Honor, this is a first PCC. We are asking for a 2-week adjournment for further discovery and investigation in this matter.
Probable cause conference adjourned March 20th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor. I'll be done. Okay, take care.
Thank you, Your Honor. Thank you. Court calls case People versus Laura Andia.
Ashelani for the people.
Assistant Public Defender Chinazi Kyriakou, Your Honor, on behalf of Miss Laura Andia, who is approaching.
Ms. Andrea, could you state your name for the record, please?
Laura Andia. Your Honor, we are asking for an adjournment in this matter. We had not had an opportunity to speak with Ms. Andia previously, but we suspect that there may be some Padilla issues that we need to
I don't. To the actual approach. Probable cause conference will be adjourned April 3rd, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Court calls the case, People versus Teresa Johnson.
Assistant Public Defender Jay Bellinger on behalf of Ms. Johnson, who approaches. Johnson, can you please state your name for the record?
No name Johnson.
Hello. All right. I have 3 plea forms. Is that going or?
That is correct, Your Honor. I have advice of rights right here. My understanding is my client's going to be pleading no contest, Your Honor. Those police reports were sent to the court.
Yes, and I reviewed those. And so starting in the case ending in 0779, the plea form indicates that the defendant will be pleading no contest to added counts 3 and 4. 3 being an attempted resisting and obstructing, 4 being an assault and battery. The first one being a 1-year offense, the other being a 93-day offense. In the case ending in 5152, plea form indicates the defendant will be pleading no contest to the charge of attempted resisting and obstructing the 1-year offense, as well as the stated count 2 of assault and battery, the 93-day offense, and count 1 would be dismissed. There's also a global agreement to 2 years probation with assessments, treatment, full restitution on all counts, even the dismissed counts. I would indicate as to the probation, I don't see that there would be an issue, but I can't bind the sentencing judges in these cases to that, but I don't see that there necessarily would be an issue regarding that. In the case ending in 5189, defendant would be pleading to the stated count 2 of assault and battery, 93-day offense, count 3, the attempted resisting and obstructing the 1-year offense, and count 1 would be dismissed along with that same global agreement. In essence, just a short of it, because there's 3 cases, Ms. Johnson, you would be pleading to 3 charges of assault and battery and 3 charges of attempted resisting and obstructing. That's the court's full understanding of the agreement.
That is our understanding as well, Your Honor.
Yes, sir.
All right. May I have her sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth self you got?
Yes, sir, I do.
State your name.
Teresa Johnson.
Okay. Ma'am, it is a court's understanding that you're going to be pleading no contest to 6 charges. Is that your understanding?
Yes, sir, it is.
3 counts of assault and battery. Those are punishable by up to 93 days in jail, up to a $500 fine plus court costs. You understand that?
Yes, sir, I do.
Also, 3 counts of attempted resisting and obstructing. Those are misdemeanors punishable by up to 1 year incarceration, a $1,000 fine plus court costs. You understand that?
Yes, sir.
All right. And do you understand what a no contest plea is?
Not guilty?
No, we discussed what a no contest plea means.
Say it again.
The no contest plea means.
You may want.
Okay, thank you. The no contest.
Now, it's hard when it's your first time in the courtroom.
But the court will take it as a guilty plea, but you don't have to say anything that you do wrong. The court's going to use the police report to form a factual basis, okay?
Okay.
All right.
Okay.
Thank you, Your Honor.
Yes, very clear.
All right. So you have a clarification now as to what a no contest plea is?
Yes, sir, I do.
All right. Tell me what you think you're doing with a no contest plea.
I don't have to plead guilty, but the court will take it as a guilty plea, but I don't have to say anything that I did right or wrong, or and what
The court's going to use the police
the
report
court's gonna use the police report
to establish
against
a
me.
factual basis.
And I'm going to assume that the information contained in that police report is true, or certainly that you're not contesting those facts.
Okay,
Understand that?
yes, sir.
Okay, do you have any questions regarding that part of?
You said, well, regarding that part, no, but you said you haven't found a sentencing, Your Honor, yet?
Pardon?
A sentencing judge yet? You haven't found one?
No. These cases, I would be taking, okay, that's
Okay,
important part for you to understand. So I need you to understand this about a no contest plea. Let's go back to it.
okay,
And hopefully when I get through things, it will all answer for you. But
thank you.
the no contest plea means that you're no longer wanting or desirous to contest these 6 charges. You understand that?
Yes. Can you
All right.
repeat what the 6 charges are again, please? Now you don't have to go in depth
No,
about it.
no,
Just
that's
give me the
okay.
title.
That's okay. If you don't hear something or understand it, I have to make sure that you do.
Okay, thank you now.
There are 3 charges of assault and battery.
Yes, sir.
Misdemeanors punishable by up to 93 days in jail, $500 fine plus court costs.
Okay,
Okay?
yes.
There are 3 charges of attempted resisting and obstructing a police officer, or yes, attempted resisting and obstructing a police officer.
Sorry.
Those are misdemeanors punishable by up to 1 year incarceration
Okay,
and a $1,000 fine plus court costs.
okay,
Okay?
yes.
It's the court's understanding you're pleading no contest to those charges.
Okay, so if I wanted to pay them off, I couldn't do that either? Can I?
Wanted to pay
Pay
them
the,
off.
like, $1,000 for the resisting and
Okay.
obstructing a police
So-
officer?
All right.
No, okay,
That's the maximum fine.
okay,
Okay? That's not a dollar amount that you could pay and just be done.
okay.
Okay? You understand that?
I believe so.
Well, I have to make sure that you understand.
Yes.
Ms. Johnson, listen. If you're not understanding,
No.
then I'm not going to take your plea.
I
So,
understand.
no, just listen.
Okay.
And it's not, I'm not mad at you about that.
Okay.
Okay?
Yes, sir.
I have to make sure that you understand what you're doing. And not all of a sudden end up in a circumstance where
Yeah.
you didn't understand why you did something or whatever.
Okay,
The other part of, just so that you know, a no contest plea is that for the purposes of sentencing, the respective courts are going to treat you the same as though you had pled guilty to these charges.
okay.
Understand that part?
Yes, sir.
Okay. Now you understand also that, I almost hate saying it, but I'm going to say it. There's an agreement between counsel that you'll be placed on probation. But because I'm not the sentencing judge in these cases.
Okay, I wish you were.
Huh?
I wish you were.
You know, I don't get that a lot. Thank you.
You're welcome.
But because I'm not the sentencing judge,
Okay,
I can't bind the sentencing judges to this agreement.
okay,
So that while that's an agreement, and from my perspective and experience, I don't see that there'd be a problem with it. They may decide something different.
okay.
You understand that?
Yes, you're not the sentencing judge, but can't make the decision based off what they might say, and they might find something different.
Yeah, they may not go along with that agreement.
Okay,
You got that?
There's no real reason to believe
Ms.
that they
Johnson,
won't. like you
Ms.
said.
Johnson, listen.
okay,
And I'm gonna make the ultimate determination, but would you want to talk with your attorney a little bit more just to make sure and be clear about what you're doing?
yes, please, I would desire that.
Okay, all right. And Ms. Johnson, that's fair,
Okay,
right? Because I want to make sure I'm explaining it, but I want somebody that's on your side to also kind of go through it with,
okay.
kind of understand it.
You're doing a great job. I'm just a little slow.
I've done a
So-
great job.
You're doing a great job. at
Yeah, say
explaining
that
it.
louder.
Okay, you're doing
No,
you're doing a great job.
Hey, thanks. All right.
Your Honor, may counsel briefly,
Nothing like fishing for compliments.
Okay.
Go ahead.
may counsel briefly approach?
You may.
Thank you.
Okay, thank you.
I'll be right back.
All righty.
Okay.
Yes, sir.
And then give you an opportunity to speak with your attorney. He'll probably speak with you certainly before that date, but then he'll speak with you on the date of that.
Okay.
Okay, so that we can then make sure that you understand everything.
Okay, yes, sir.
Okay,
Thank you.
and just so that you know, you're not in any trouble or anything like that
Okay.
for asking the question.
Thank you.
You know,
Appreciate that.
I have to make sure that you understand, and I'll, you know, that everything's answered for you before you
Yes,
do.
sir.
All right.
You're doing a great job, Simpson.
Thank you, Mr. All right.
All right.
I'll adjourn these
We'll
to the
talk soon.
20th.
Okay,
Take
thank
care.
you.
All right, thank you. Court does call the case, People versus Neil Hines.